Michael, how are you?
I'm wonderful, Maya. Thank you kindly for asking. What about you?
I'm fine, thank you. It's nice to see you. Happy holidays. We're recording this over the holiday season, so I'm grateful that you were able to take some time to chat with me today about this. And you're a new guest on the series, so welcome to
Thank you very much.
the Wicked YouTube series. And because you're a new guest, I would like you to first start by introducing yourself, Michael, to our viewers, and then we'll talk about the topic that we're here to chat about today.
Thank you generously. My name is Michael Johnston. I am a barrister at law who practices predominantly and almost exclusively criminal law with some quasi-criminal law, but really criminal law writ large. I don't specialize in any one particular case per se, but always interested in the various subject areas that criminal law provides us an opportunity to engage in on behalf of our clients. And I do have a pronounced or a particular interest in trial by jury when the situation and occasion appropriately allows.
All right. So, since you mentioned trial by jury, and this is actually what we're going to be talking about today, let's get into that topic. And first of all, I wanted to congratulate you because you have a book that just got out on LexisNexis, and we're here actually to talk about this book because it's an interesting one. It is actually about jury trials. So let's start by talking about, first of all, why did you write this book, Michael? And I should mention that the link for anyone who's interested in purchasing the book will be provided in the YouTube description of this episode. It's available via LexisNexis, and the book's name is The People's Champion Trial by Jury. So if you can tell us, why did you write this book?
I wrote the book predominantly out of my own necessity, I would say. I've been in practice now for 14 years, and I've had the great pleasure of practicing the entirety of my practice with Leonard Shore, QC, or I guess KC now, who, to my mind, is a superlative trial lawyer and somebody who always appreciated the benefit that trial by jury provides to clients in the appropriate circumstances. But that said, early on in my career, and even though I had a wonderful opportunity to article with Brian Greenspan and David Humphrey, there wasn't that much that I knew. I felt coming out of law school and coming out of my articles with respect to trial by jury. And all that's to say, I had a wonderful opportunity while I was articling to travel to Goderich, Ontario, and to be involved in a multi-week judge and jury trial on a conspiracy or counseling to commit murder case. But beyond that one experience, I felt like going into my actual first and couple years of practice, I was comparatively ill-equipped to run a trial by jury, though it was something that always fascinated me because it's so hallowed and spoken about with such great enthusiasm by various people. So in starting to do my own initial files, not all of them at the start were trial by juries. Rather, I did small assault cases, or I did small impaired driving cases, always with an eye to wanting to expand my practice to trial by jury. And so there wasn't very much around, at least that I could locate. I know that there are some resources. There's a wonderful book called The Jury Handbook of Law and Procedure that's written by Balfour Dare. Great resource, but it's a little over $2,000 if I remember correctly, and wasn't that widely available. I certainly didn't know about it back in the day, some 14 years ago. So I ended up writing this book not intentionally, almost just as a function of starting to run jury trials and starting to piece together the different components of the trial for my own edification. And then at a certain point, I thought, well, because there may be this comparative paucity, like you don't get taught too much about it in law school. I don't remember there being a student's handbook or anything of that nature. I just figured that I could compile something that would begin discussing the various aspects and have individuals start to think critically about how the different pieces of a jury trial add up together and perhaps provide some benefit accordingly. So that's kind of how it was born. I've really been writing it, I guess, for the better part of 4 or 5 years. There was a point where I paused in and around 2019 because of the imminent change that was proposed and ultimately took place as a function of Bill C-75. So I was writing it since about that time, and then I paused and became myself involved in testifying at the House of Commons, opposing the elimination of peremptory challenges, for example, or opposing the elimination of triers for the challenge for cause, testifying at the Senate, and ultimately acting as an intervener at the Supreme Court of Canada in Regina and Chouhan, endeavoring with what little ability I have to stop the elimination of what I think were and are important procedures that have long been associated with trial by jury. So all that's to say, it's something that was written out of necessity and out of my own experiences, and it's been a slow process, but there's always been a little bit of progress, and hopefully now the book is something that people can pick up and read about these different areas with some ease and obviously a lot of research will still be on their plate to further determine the depth of their knowledge on any one subject. But it's just hopefully a one-stop shop for law students and young advocates to provide them with a bit of knowledge that maybe I didn't immediately have and may have wished was more readily available.
Okay, thank you, Michael, for this answer. Now, I just wanted to ask you, how long is the book? Like, how many pages?
It is about 525 pages, if my memory
Mhm.
serves correctly. There are a couple of appendices that make it a bit longer than it otherwise would be. But for example, Brian Greenspan very generously let me use a closing address from a case called Regina and Stephen Murray, which was a second-degree murder case out of Goderich. Goderich is being mentioned twice here.
Yeah.
But yeah, Mr. Greenspan generously let me use his closing address in that case, which resulted in an acquittal in about 20 or 25 minutes on that murder charge. So it's one of the appendices, and that's 30 or 40 pages in length. And then
Okay.
there's a couple of other appendices that are a bit longer. So the book, it's not uh, 20 or 30 pages. It's not a pamphlet per se, but hopefully it's not too long either.
And how much is it selling on LexisNexis?
I believe its retail price is $125.
Okay. So that's a pretty reasonable price for the book. So hopefully it will be also something that students will be and new lawyers will be able to afford. But let's get more into the content of the book then, because you mentioned that there are some appendices and that there is like a closing, a sample closing to the jury. So I'm guessing that you tried to make this book more like a practical tool for lawyers, or is it a combination of practical tools and a little bit of academic? Like, does it get into the history of jury trials, or what is it exactly? Is it a combination, or is it just theory, or is it practice oriented, or both?
It's a bit of both, Maya. I mean, it necessarily does engage in a brief history of trial
Mhm.
by jury. And I say a brief history, but I think the chapter on a brief history is some 20 or 25 pages, perhaps, dealing with, for example, what existed as legal institutions previous to the Norman Conquest and how, uh, with the Norman Conquest there was William the Conqueror bringing over the Royal Inquisito and how the Royal Inquisito ends up being adopted through the Assizes of Clarendon in 1166, and how that was used to stay trial by battle, and then how presentment juries then became used as judgment juries when the church would no longer permit the use of ordeals for the purpose of discerning divine judgment. So, and then how the judgment jury that we start seeing in 1218 then evolves to have various procedures for the selection and challenging of jurors and things of that matter, in my estimate, and how trial by jury comes from England into the colonies, and what changes happened during the 19th and 20th century, because both obviously the United States and Canada were themselves colonies of Great Britain, and there is a bit of a distinction in how juries operate, let's say in the United States, and their jury selection process and voir dire, and how ours is currently. So a bit of that history is discussed, because we felt, or I felt, that it was important to be able to better understand trial by jury as it currently exists in its current context. So there's a historical piece there, but then there's also things such as, well, practically speaking, why might you want to have a trial by jury? Because not every offense requires a trial by jury. Of course, we have Section 469 of the Criminal Code that mandates trial by jury for certain offenses. And then we also have, off the top of my head, I believe it's Section 471 of the Criminal Code, or 472. I'm sorry if I'm off by one, but it makes trial by jury the presumptive mode of trial for all indictable offenses, save for the exceptions that are written into the code. So, for example, where indictable offenses are in the absolute jurisdiction of the provincial court, there's no option for trial by jury. But then just discussing, well, if you have the option for a trial by jury, why might you wish to have a trial by jury? What are the pros? What are the cons? What are things to think about? Sections of the book then discuss things like eligibility based on various offenses. There's discussions with respect to elections and re-elections in terms of trial by jury. There's constitutional considerations as it exists, pertaining particularly to 11F and a little bit about 11D, and the various components that we've been able to distill since this constitutional project has been undertaken. Because trial by jury, as many of us likely well know, was institutionalized or constitutionalized in 1982, but previous to that, it wasn't a component of our Constitution. So, in the 1960 Bill of Rights, or the Diefenbaker Bill of Rights, there's no mention of trial by jury. So it's still a comparatively new project, this idea of what was constitutionally guaranteed in 1982, and how is that going to continue to blossom as a living tree while remaining respectful of the roots that were implanted. And then, there's various other there's chapters that talk about challenge to the poll, challenge to the array, what types of challenge for cause there might be, what type of pretrial motions one might consider in terms of bringing, if you have a trial by jury, what type of questions might be asked during the challenge for cause process, open-ended questions, multiple choice questions, whether the attitudinal and behavioral questions are to be rolled up, or whether they are to be deconstructed, what to consider in terms of an opening statement, what to consider in terms of a closing statement, what might be discussed at a pre-charge conference, what might be considered in terms of a mistrial, what might, for example, and one of the important subjects that at least I've dedicated quite a bit of ink to in the book is discussing one of trial by jury's most fascinating components, and that's the power that juries still have in our country to nullify when they think that returning a verdict of a particular persuasion would be contrary to their conscience. So there's quite a bit discussing the jury's power to nullify, and how that is currently viewed in our system. Sorry if that's a bit of a long-winded answer, but I was just trying to give you a flavor of the various subjects and topics that the book tries to cover.
Yes, and I should mention that I see here on the LexisNexis page for the book, there is a summary of the topics that are covered. So for anyone who wants to read about that, it's available online on LexisNexis's web page for the book. And you did mention that there were a few appendices, and one of them is a closing. What else is there? Like those are really interesting tools, practical tools that lawyers are often looking for. So, what else is there, Michael?
Well, I know that at least two of the appendices, one is a factum that was submitted to the
Mhm.
Supreme Court of Canada by myself and Solomon Friedman on behalf of the Defense Counsel Association of Ottawa for the Regina and Chouhan case, dealing particularly with peremptory challenges and static or rotating triers for the challenge for cause process. That's included because there isn't very much discussion in the book about challenges to the poll, because the challenges to the poll are currently challenges for cause. Previously, we of course had peremptory challenges, but because those have been eliminated since Bill C-75 and September the 19th, 2020, I think was the or September the 19th, 2020 or 2019. I'm sorry if that date is inaccurate, but as of now, several years ago, we've gotten rid of peremptory challenges. So I thought it might be beneficial rather than having a long-winded discussion about the pros and cons of peremptory challenges to include the factum that we submitted that ended up being heavily adopted by Justice Cote in our estimation in her dissent in Chouhan, and similarly the brief that I provided to Parliament at both the House of Commons and the Senate opposing the elimination of peremptory challenges included in there just to see what was an important component of trial by jury, particularly in my first kind of 10 years at the bar and learning about this institution. And maybe that's just now been consigned to history, and maybe that's why it was thought that it was better to be included as an appendice if people wanted to know a bit more about this, but it's not otherwise figuring in the substantive pages of the text. So those are some of the appendices.
All right. And I wanted to ask you, Michael, because many of, especially new lawyers, for them, the concept of a jury trial can be intimidating, could be scary. It's a lot of work. It's very different from a judge alone trial, and there's more of a performance aspect to a jury trial that we don't necessarily have in a judge alone trial. So I know this book is going to help a lot of people who have fear and anxiety, who feel like they don't know what they're doing. So this is a good way to read about jury trials before doing them. But what else can you give as advice for new lawyers about jury trials so that, like just to ease a bit that fear and that anxiety that comes with those types of trials?
Well, something that you said, Maya, that suggested itself to me was this idea of it being a lot more work, and it is. It's more work because there are more procedures in place, and those procedures are generally well conceived of. They're in place to ensure that as little as possible that's prejudicial goes before the jury. So we have a lot more pretrial motions to try and separate the wheat from the evidentiary chaff, as it were, before you get the jury in there. And of course, the selection procedure and the pre-charge conference, and then the closing addresses of counsel and the deliberations, that of course increases the length of what sometimes might be a 2 or 3 day trial in the provincial court. And if eligible, that might be now a 2 week case in the superior court. And some people will look at that and not determine that it's perhaps of great benefit. I mean, from an immediate perspective, one of the things that I've always found fascinating is trial by jury automatically increases your client's ability to remain not guilty. They're, of course, presumed not guilty, but the outcomes of a trial by jury provide that they can, of course, uh, maintain the presumption of innocence and be acquitted, or they can be found guilty, but they can also result in a hung jury. And then that presents kind of a third option. And two of those options are options that do not result in a conviction to your client. And should the Crown choose to prosecute or re-prosecute, I should say, then that's obviously going to be more work again. But these are things that are potentially of benefit to your client. One thing that you also said, that they may be more performative. And it I'm not sure that I would totally agree with that. We certainly advocate and litigate a bit differently in front of a jury than we might, let's say, before an appeal court or even before a superior court. But what the jury, some of the brilliance of the jury is that we have 12 ordinary people that I don't think are easily bamboozled by snake oil salesmen. That there's little performance to my mind, and the great brilliance of the jury is that they're there and capable of seeing truths and factual realities with greater ease.
There's more common sense, right? In other words,
Precisely.
yeah.
So, I mean, while it's nervous because whereas when you're running a trial with one judge, you may have to manage the relationship that you have with the judge and the Crown attorney, versus now in a jury trial, you have to manage whatever relationships you have, obviously, in court with those 12 jurors and the judge. You have a greater audience, but it shouldn't be thought of as being inherently intimidating. If anything, it is a great tool that we don't often enough conceive of as being a good option for our clients, particularly where the great issues in a case are factual issues
Right.
more than legal ones. And that's where this opportunity to get the community involved and demonstrate their brilliance as fact finders and their ability to be a conscionable court well suggests itself. And again, you get more chances at winning just by there being three potential verdicts, as it were: hung jury, not guilty, and ultimately guilty. So there's much to be said about contemplating this as a form of justice for you and your clients, and it is going to take a little bit more work. But once you start to run these trials, you start to see that they have a very important part to play in the lives and decisions of your clients and your own practice. And just like anything else, it behooves us to better understand the various assets and facets of our profession.
Now, I do want to ask you here about something. It's very specific to the Ottawa and East region because you practice mainly in Ottawa. A lot of people and a lot of practicing lawyers in Ottawa are a little bit, especially in cases where you don't have to go by a jury trial, they're a little bit, let's say, nervous about the concept of jury trials because Ottawa seems to be a jurisdiction where a lot of convictions happen. So even on a jury trial level. So that is a bit of a concern also that has been expressed by many practicing lawyers in Ottawa. So I will let you argue as to why, despite that, we should still go with the option of a jury trial and consider that option even in Ottawa.
Well, I'd begin by saying that that's certainly a bit of dogma that I have myself heard and recall hearing it right when I was called to the bar back in 2010. A lot of people were of the particular view that Ottawa may happen to have juries that have a greater propensity to convict. And part of the reason articulated, or at least what I understood, was that there was a lot of civil servants, and perhaps federal civil servants have this greater propensity to convict. So for better or for worse, I wasn't prepared to accept that as a proposition. And the person with whom I've practiced for the entirety of my legal career, Leonard Shore, is a big believer in juries and didn't think that juries were inherently convicting or hanging juries here in Ottawa any more than they were anywhere else. So, to the extent that I had to concern myself with the potential for having too many civil servants. This was back in the day when we were permitted to have peremptory challenges, and I just exercised peremptory challenges as against most of the civil servants that were being proposed to sit on the jury. And my first four jury trials in a row were Ottawa jury trials, and my clients were all acquitted. So I didn't anecdotally share that view. If anything, I felt like I was proving the orthodoxy of the day incorrect, and I don't personally see the downside to Ottawa juries any more than juries in various jurisdictions. I mean, I've had jury trials all throughout Ontario and even in Alberta. And I think at the end of the day, it depends on the case and it depends on how it's litigated, but it remains a very good option. And this idea that Ottawa juries are more likely to convict, I guess it really is going to depend on the lawyer, the case. I don't know that that's something that's still widely shared by my colleagues. I have at times spoken with younger advocates who have never run jury trials, and they certainly tell me that as a reason for them not running it. And at the end of the day, one of the things that I think is important is to not accept the conclusions of other people's thinking and to determine whether or not what is being said is true for us. And it hasn't been true for me at the very least. Otherwise, I don't think I would have spent all the years since running those early jury trials trying to cobble together this book with the aspiration that other people may see it as a viable mechanism for achieving the justice that their clients and causes deserve.
And what about the diversity of the jury in Ottawa?
I mean, Ottawa can have diverse jury roles. I've certainly had individuals of all ethnicities on juries here in Ottawa, not perhaps with the greatest frequency. So if I think back to the past couple trials, I can think that I would have perhaps uh, one black person or one obvious Muslim person or two Muslim people. I don't know that I've ever had many, if any, indigenous people on our jury rolls, let alone on our petite juries. But I mean, that's about the most that I can say about that. I mean,
Okay.
as I understand the approach to representativeness, that's of course a function of the out of court process and the method used for compiling the jury roll and then thereafter uh, ensuring that the appropriate notices are sent out in a fair, a random way with no intention to exclude a particular segment of society. And I know there was a problem up until about, and pardon me if I don't get the date correct, but it was about 2018 or 2019 where Madam Justice Toscano Racamo did a report and appreciated that one of the problems, at least with the representativeness of juries in Ontario, was based on the Jury Act. At the time, the source list for jury lists and jury rolls was a function of the Municipal Property Assessment Center, the MPAC, I believe it was. And so obviously, if you didn't kind of own property, there was a greater chance that you wouldn't be included as a potential juror or veneerman. And so that was changed as a function of that report, as I understand it, such that the Juries Act now draws its name through information provided by the Minister of Health, if my memory serves correctly. So I believe that has likely also had an impact on the representativeness and the efforts that are made to ensure a random cross-section of society is given an opportunity to sit in judgment of their fellow citizens.
Right. And of course, here just to end this chat on jury trials, one thing I think that was important that was mentioned during this discussion is that there is more room here for common sense in a jury trial. That is also very important sometimes in a case that we see less of in a judge alone trial, where the focus is always on the legal issues mainly and less on common sense. So I find I agree that in a case, a factual case where common sense is the driving force, a jury trial is maybe the best option to for the client and to defend the client.
That's certainly a feeling that many people that are advocates of the jury system articulate. And again, the notion that juries in some ways are a last bastion of courts of equity, because jurors obviously hold it in their particular power at the end of the case to find the facts, and they are told that they must apply the law, and ultimately they render a general verdict. And the amount to which they take from the facts and take from the law is something that we can never know. And that's why the power of nullification exists, because of secret deliberations. But there is also this inherent belief that juries will come to the right conclusion based on the equities of the case. And sometimes where somebody might be, according to the law, technically guilty, they may exercise their prerogative and find a person not guilty. We may not see this with the same frequency as happened, let's say, during the 17th century. I know Blackstone talked about it and called it pious perjury, where at the time that England was governed by the Bloody Code, and individuals would be subject to capital punishment if they had stolen goods in excess of a certain amount of pounds or shillings. Juries would serve as a humanizing factor, and return verdicts that would perhaps find the person guilty but spare them their proverbial and literal neck. So to the extent to which a jury may return an equitable verdict in the teeth of the law that is given to them and the facts they otherwise may find, remains one of the brilliant features of trial by jury. I know that the four kind of functions that have time and again been found to be realized by the jury is this idea that they're an excellent fact finder, that the use of the jury and public accountability through regular individuals being involved increases kind of citizens' trust in the jury system. But then also we have a decision-making body that is the conscience of our community, and in many ways can serve as this kind of final bulwark and say, no, we won't allow the application of these laws through this verdict because we would find it unconscionable. So that remains to my mind, one of the brilliant aspects of this institution that is at once legal but also political. And I hate to harken back to Thomas Jefferson, but I think he was quite a wise individual when he said that trial by jury is the only anchor yet devised by which a government can be held accountable to the principles of its constitution. And I think that it remains an important institution that all of us who practice criminal law should be apprised of and consider as an option for our clients should the proper opportunity present itself.
Well, thank you so much, Michael, for this lovely chat about jury trials and your book. I'm sure a lot of people will want to buy this book, especially newer lawyers, but it's not just for new lawyers and students or articling students. It's also a useful tool even for lawyers who have been practicing for a while, because if I look here at the topics that are covered, like it's a good guide for lawyers. If they have any questions, they can go to that book and seek answers. for some of the questions that they have. So I would encourage everyone to get that book. It's available now on LexisNexis. Again, the link will be provided in the description of this episode on YouTube. And Michael, if any lawyer wants to get in touch with you or a student, where and how can they find you?
They could get in touch with me through my email that I can easily provide to you, or my website is pretty easy to find as well. It's www.sjhdlaw.ca.
So I will include that information as well in the description so that if anyone has questions and wants to get in touch with you, I know that for a lot of lawyers who practice in the East region, if you're looking for someone who does a lot of jury trials and you just want to ask advice or you have questions, Michael is a good person to get in touch with. So thank you so much, Michael,
It's
for
been my
your
pleasure.
time today, and congratulations again on the new book.
Thank you kindly, Maya, and have a wonderful rest of your holiday season.
You as well. Thank you.